Good morning. Welcome back to Representing LGBT Asylum Seekers. We're on part 2 today. My name is Olivia Judd. I use she, her pronouns, and I'm a senior attorney with the National Immigrant Justice Center's LGBT Immigrant Rights Initiative.
Hello, and my name is Hannah Levine. I use they, them pronouns, and I am a paralegal with our LGBT project.
Good morning. My name is Lee Vanderlinden. I also use they, them pronouns. I am a supervising attorney on the LGBT team.
I'm going to go back through some of the housekeeping things we reviewed during part 1. There is a question and answer tab in the control panel on GoToWebinar. Please feel free to drop questions in the chat as they occur to you. When we can, we will respond to them in real time, but for the most part, we plan to hold questions and address them at the end. If you have a question that we're not able to get to today, please do feel free to reach out. My contact information will be in a slide at the end of the presentation. We would love to hear from you and make sure that all of your questions are addressed. If you did not enter your ARDC number when you registered, please email it to us so we can be sure to get you your CLE certificate. Also, there are handouts in the control panel. There is a copy of the PowerPoint slides, as well as additional resources and materials. And then finally, this presentation is intended to assist attorneys and accredited representatives in preparing asylum applications. It is not intended to assist others in providing legal advice or the unauthorized practice of law. Next slide, please. Thanks. To recap, the National Immigrant Justice Center is an agency of Heartland Alliance. NIJC is dedicated to ensuring human rights protections and access to justice for all, immigrants, refugees, and asylum seekers, both on the individual and systemic level. There are 3 pillars to our work: legal services, federal impact litigation, and policy and advocacy. We draw heavily on our experiences in direct services to inform our litigation and policy strategies. And so the issues that we see, right, directly from our clients and directly from our pro bono clients are being relayed back to our litigation and policy teams on a regular basis. So it's not uncommon for pro bonos to alert us to things that they're seeing in their cases, and we really encourage you to reach out with those kinds of concerns so that we can connect you as appropriate with our litigation and policy teams. Next slide. We offer a multitude of resources for pro bono attorneys. There are many on our website. There are some in the handouts section today. No need to take detailed notes. We have a full asylum practice manual for folks to draw on, and also for anyone taking a pro bono case with NIJC, you will be assigned a point of contact who will be able to follow up directly with samples, technical support, and other kinds of advice throughout the lifespan of the case. Next slide. Today, we are going into part 2. I know we talked a lot about asylum law in part 1, and I'm going to read out this asterisk here that while we're referring, right, these presentations are about asylum, and while we are referring to asylum throughout, we are also including withholding of removal and protections under the Convention Against Torture, kind of under that umbrella of humanitarian protection when we refer to asylum in these presentations. So I'm going to start us out today talking a little bit about how to prepare an asylum case, and then I'll pass it on to my colleagues to talk more about specifics of representing LGBT asylum seekers in these cases, and then I'll hand it over to Lee to talk about what it looks like to present an asylum case in front of the asylum office or immigration court. Next slide, please. All right, we are going to talk first about preparing your case, and we can dive right into the next slide. So first thing to know, we talked a little bit in part 1 about affirmative versus defensive asylum proceedings. So the first thing to know is your client in removal proceedings? Where is your client venued? Are they with the immigration court or the asylum office? A notice to appear is a charging document that places an individual in removal proceedings. So you're going to want to find out right away if your client has a notice to appear. This is information that we include in our case blurbs, right? We always include the procedural posture. We will let you know going into a case where it's venued and what to expect. A procedural thing to note here is that something we've been seeing recently is clients who maybe are stopped at the border or on entering the United States are issued notices to appear, but then those notices to appear are not filed with the immigration court in a timely manner. So someone is only in removal proceedings, is only in immigration court proceedings once the NTA has been filed with the court. If someone comes to us and they've been issued an NTA, but that NTA isn't filed with the court, that court has no record of the individual, there is no file, there is no way to file applications, right? Because the court has no record of that individual. So what we do in that situation is we file applications affirmatively with USCIS in order to preserve the one-year deadline. And then the case is later referred over to immigration court and it proceeds, as normal in removal proceedings. So step one, check if your client has an NTA, figure out the procedural posture of your case. Again, that's information we share prior to placing cases and that your point person at NIJC will certainly be able to help you navigate. Next slide, please. Thank you. All right, so now you're taking a case. Where do you start? First, review NIJC's file, get a sense for what's going on, get yourself really grounded and oriented in that case. Second, if your client is in removal proceedings, you're going to want to file a notice of appearance as attorney with the court as soon as possible. You do not want to miss learning about a client's hearing. So right away, you're going to get your notice of appearance on file. It is called Form E28, and you are going to need to register in order to be able to file things and appear in immigration court. There are instructions online on our website. And again, that's something that NIJC staff is happy to help you navigate if questions arise. This is also a good time to flag that the court, I believe last year, moved to an electronic filing system. So cases that have been recently filed in immigration court are fully online through this ECAS system, and filings are only allowed online for those cases. Older cases filed and started before the conversion to an online system are paper files, and those filings can only be submitted on paper. So that's another thing to kind of get oriented with in your case. Find out if you're going to be filing electronically or on paper throughout the lifespan of your case, because your filing will be rejected if it's done in a way that's not in accordance with how the court has the case file set up. Next, get deadlines on the calendar. We talked in part one about the one-year filing deadline. That is not a flexible deadline. I strongly recommend getting not just the one-year filing deadline on the calendar, but making sure that you have a plan to get that application filed far enough in advance that you are not in any doubt that it was timely filed. Get any court hearings on the calendar. Again, if someone misses a court hearing, they can be ordered removed in absentia. We don't want to go there or end up there. Make sure hearings are on the calendar. Make sure that your appearance is filed with the court so that you're getting notices about any changes in hearing times. And then employment authorization documents, also more informally known as work permits, are really critical. And these might be actually things that your clients are asking you about the most, right? Because work permits allow access to a social security number, to a driver's license, right? The ability to find lawful employment, and that can really be like a critical source of stability for our clients. Asylum seekers are eligible to apply for work authorization 150 days after their asylum application is filed. I will say we had a lot of regulation changes in the past couple of years. At this current time, the rule is 150 days. So if you're the one filing your client's asylum application, the day that you know it's been received either by USCIS or by the court, map out those 150 days and get that date on the calendar and have a plan to get your client's EAD application filed as close to that 150 days as possible. Now, there may be some other cases where maybe client already has an EAD. Sometimes for court cases, NIJC files the I-589 asylum application and places it with pro bonos closer to a scheduled hearing date. So for instances like those, you'll want to check, is your client's eligibility for a work permit coming up? Do they have a work permit that's going to expire? Get those dates on the calendar and have a plan to make sure that your client isn't losing or missing out on an opportunity for work authorization. And then finally, there is a hotline and website portal for the immigration court where you can check client hearing dates. So the phone number is here on the screen, 1-800-898-7180, as is the website. We recommend checking it every other week if your client has been issued an NTA that has not been filed with the court. Honestly, even if you have a hearing date, it's good to check it regularly because hearing dates can change and our mail can be quite slow, and so you might get faster notice if you're checking this portal regularly or checking the hotline regularly than you would if you're just waiting to see what comes in the mail. But especially if your client has been NTA'd, you want to be checking that to check whether or not the NTA has been filed with the court or not. If it's not been filed, it will show up as a no match. If it has been filed, you'll be able to see the client's case information. All right, we can go to the next slide. All right, so you're set up with your case. You know whether or not, you know where your client's venued. You are getting ready to work up the case. What do you need to file? It's actually quite similar whether your client is in front of the asylum office or immigration court. For the initial filing, they're pretty short. We're not going to spend a lot of time on it. It's your appearance, an E28 if you're in court. It's a G28 if you're venued at the asylum office. And then the asylum application itself and maybe an identity document is your initial filing. Your supplemental filing, which you submit in the lead up to the hearing, whether it's an asylum interview or a merits hearing with an immigration judge, is going to be where the bulk of the work for these cases come from. So in each case, it includes legal arguments. With the asylum office, they are generally shorter and more streamlined in a legal memo. In immigration court, you might have a longer immigration brief. And then in both places, you're also filing a client affidavit or declaration, an annotated index, and then supporting documentation, which includes country conditions, expert affidavits, letters of support, and other corroboration relevant to your case. I will briefly note here that affirmative proceedings with the asylum office are non-adversarial. You do need to file an original filing and an extra copy with the asylum office, but you don't have to serve a copy of your filing on anyone else. If you're in immigration court, anything that you give to the immigration court, you need to serve a copy on the government, and that can be done either online through e-service or through mail or courier service. As you think about these pieces, we ask you to keep in mind that this isn't a linear process. You don't work up one set of evidence and then move on to the next and then move on to writing the brief at the end. These all really inform each other. As you write the affidavit, you might learn about an event and want to get corroboration relevant to it. As you go through your corroborating evidence, you might have a letter from a friend, or you might get a forensic exam, and it might prompt some questions that you want to ask and add some information to the affidavit. And then, of course, as you write the legal argument and you figure out how you're going to be framing this case, you may it may prompt you to kind of look at how you're framing the affidavit and the other evidence and making sure all the pieces fit together. So while I usually try to get the affidavit off the ground as soon as possible to really dig into the client's asylum claim and understand the facts, those other two pieces really need to be coming along in tandem. Corroborating evidence can take time to gather if it involves getting records or reports or letters from other people or going in for medical or psych exams. And then, of course, the legal argument, really, I advise against waiting until the last minute with it, just because there is so much interplay between those other pieces of the case and how you work them into the legal argument and how it informs your framing of the rest of your evidence. Next slide, please. Thank you. All right. You know the procedural posture of your case. You have done the basics, you've reviewed the case file, you've gotten yourself set up kind of administratively and logistically. What does the launch of a case look like? First, of course, you have to get in touch with the client. And when you do this, you're going to want to explain your role. We do try to prep clients to understand the relationship between our pro bono partners and NIJC. It can be confusing for clients to navigate, so going over that again, explaining confidentiality is crucial. Also, making a plan for communication, right? This is scary to be applying for asylum, and so having some reassurance about when and how a client is going to be in touch with you is really important. Often this looks like weekly meetings at first, maybe bi-weekly, depending on your client, your schedule, the client's schedule, the needs of the case. But there may also be times when cases fall into periods where not a lot is happening. Maybe you've worked up the materials and now you're waiting for an interview or you're waiting for a hearing date. And so setting an expectation with clients of like, not a lot is happening right now and we know that, but we're going to check in once a month or every other week, right? Depending again on the client's needs, can be really reassuring, and it can save both you and the client a lot of stress of having kind of randomized check-ins, wondering, you know, what's going on or feeling disconnected from one another. And then of course, get any form signed that you're going to need. You don't need a client signature on the E28. You do on the G28 if you're filing at the asylum office. Start gathering records and immigration history. There is no discovery in immigration proceedings, so the information you have to work with is the information that you can find. You can request a full copy of your client's file from the immigration court if they have, you know, if they've been in proceedings for a while and they might have some kind of a record. If your client had border patrol contact but doesn't really remember or doesn't have a clear record of it, you can FOIA for those requests. If your client did a credible fear interview where they have already been interviewed by the government about their asylum claim, you're going to want to get a copy of that, right, to make sure it's consistent with anything that you're filing or that you can explain any potential discrepancies. And then, of course, you're going to need to actually work up the asylum application, which is Form I-589. We're not going to get deeply into that today because it is a form with pretty clear instructions available on the USCIS website, and we also have procedures and checklists available through our own materials. But I do want to note that when you file an asylum application with USCIS, you will get a receipt notice in the mail, usually within about 2 to 4, maybe 6 weeks, depending on how slow things are at that moment, confirming receipt. When you file in immigration court, you need to be getting a date stamped copy from the court so that you have proof that that asylum application was filed in advance of the 1-year deadline. And you can do that either by filing at the window and having it stamped, by mailing a copy and including a return envelope to get your stamped copy back, or if you are filing online for your case, you'll get a confirmation email and make sure to save the PDF or take a screenshot in the portal so you have that proof. And then you will turn to drafting the affidavit or declaration, which we will get into more detail on these next slides. I'm going to just start by reading this all caps, highlighted yellow, underlined text at the bottom of this slide. Your client's affidavit is the most important evidence in your case. This is going to have kind of be the crux of the evidence, right? Asylum seekers, when they are fleeing from their countries of origin, may or may not have a lot of access to other evidence. And we'll get into more about getting additional corroboration in later slides. But the heart of this claim, right, where it's all going to be laid out is in the affidavit or declaration. And that's going to be used by an adjudicator to assess the client's credibility. So it's really important that the affidavit is comprehensive. It's written in a way that is in accordance with how the client expresses themselves, right? And that it's going to be understandable and easy to follow by an adjudicator. Next slide, please. As you work with your client to put together the affidavit, it's really important to understand that, as Lee mentioned in part 1, asylum seekers are almost definitionally trauma survivors. So you may not be able to just sit down and crank out an affidavit or declaration with your client. That really may not be a healthy space for them. And so as much as you're learning about asylum here, you're also learning about working with trauma survivors and meeting them where they're at. So I really encourage you all, as you sit down with clients, to bring a lot of curiosity about your client and their headspace, finding out what's going to work for them, finding out whether, this says maintain frequent contact and for a limited duration, and that's often the case. There are also times when someone wants to sit down for a longer period of time and get a lot of information out there and then be able to put that away and not think about it for a little bit. So really never assuming what's going to be best for your client, but asking and providing choices throughout the process. So as an example of this, I worked on an affidavit a couple of weeks ago with the daughter of one of our clients, and she was born after most of the persecution happened. It was, a pretty limited affidavit, and it seemed like something we could get done pretty quickly. And so we had initially planned to meet for an hour, and after 25 minutes, we'd actually gotten through half the affidavit, and she was doing great. She was like really able to explain kind of answers to the questions I was asking really, really clearly. She seemed like she was really focused and hanging in there with me. But when we got to that halfway point, even though it had only been 25 minutes and we'd reserved an hour, I told her, like, I think we're about halfway. Do you want to keep going today, or do you want to take a pause and check back in next week? And she said, this is bringing up a lot for, like, I had never really thought in detail about my mom's asylum case and what she went through, and I am having a lot of feelings right now. Can we take a pause and come back another time? And so of course that's what we did. But like I said, she wasn't really giving any indicators directly through our conversation that she was hitting a wall or a breaking point. So it's been really important to just build in opportunities to ask and take breaks, and also to empower clients, right, to speak up and advocate for themselves when they want a break. Choices can also help, right? Like, we can work on this section of the affidavit today, or we can work on this other section, or here are 4 things we're going to have to talk about. Like, which one do you want to start with today? Can be helpful. We can talk by phone, we can talk in person, we can talk by video. If you don't feel comfortable sharing something, you can send me an email, or you can tell your therapist or your doctor, or you can have them share. To give another example, worked for a while with a client on a political opinion claim. We had been kind of giving him options throughout about how to share information. He was, I think, forthcoming because he knew that it would help his case, but you could tell that he wasn't really comfortable talking about, a lot of things. And we'd been really focused on like this one specific like angle of his case, right? And we'd spent maybe 4 affidavit sessions talking about it. And he walked in one day and he just handed me a piece of paper, and it was a medical diagnosis. It was a letter from his doctor explaining that he's HIV positive. And so that was clearly something that he did not want to tell us outright in a conversation, but that once it had been disclosed to us in writing, we were able to set up ways to talk with him about it, right? It actually ended up being really important to that case, having that information and learning more about like access to HIV medicine in his country of origin, right? And so it was really critical that he'd found a comfortable way to tell us, even though it wasn't something that had come up directly in our initial sessions. So kind of to go off of that too, leave yourselves time. Things are going to come up throughout the process, right? Clients are going to remember things later because of how memory works in general, and particularly memory of trauma survivors. There might be things that clients don't remember at all, or memories might start resurfacing throughout the process, and just be prepared for that and be ready to be patient with that. We also really make an effort to provide mental health referrals to clients, and that's something that I usually do in advance of starting affidavit prep, is to kind of assess whether a client already has therapy, wants therapy, has never thought about therapy, and doesn't think it's for them. But to let them know that the affidavit process can bring up really, right, a lot of memories and feelings, and to let them know that there are supports available, and we're happy to provide those referrals or help make those connections if needed. And then finally, in terms of setting up these interviews, this says bookend the interview. I think of it as a bell curve, right, of starting out with information that's not too intense, working your way in each session towards whatever the most intense information you need to get is, and then working your way back down and ending on something that is less traumatizing. So often I'll start with some fact gathering, right? Like, oh, we need to do dates of birth, or we need to do locations of family members, right? Something that's not usually too difficult. Work our way into those really substantive questions. And then a lot of times at the end of the interview, I will try to find something that's really a source of joy or pride for the client, right? So maybe they've owned a business, or maybe they have like a niece or nephew that they're really excited about or close to, right? Or maybe they have an activity coming up this weekend. And again, I want to note that as we talk about that another technique that we use, right, is to explain what information we're asking for and why we need it. And so we do that throughout the interview. And so maybe at the end, a question might not be strictly relevant to the application, and I'll usually say, like, hey, no pressure to talk about this. This is not specifically, related to your asylum claim, but I do kind of want to know about you as a person. You mentioned that you are an artist. Like, would you be willing to tell me a little bit about your artwork? And that can really help create a strong client, like not just help end the interview on a more positive note, but create a strong client relationship and help them feel safe and comfortable and seen with you. Go on to the next slide. When it comes to actually writing the affidavit or declaration, there's kind of a fine balance to find here, right? Your job is to make it clear and understandable and organized so that an adjudicator can easily match the facts of the case to the law. But this isn't a legal memo. This is the client's document, and it should be in the client's voice. So I kind of try to think of it as like being a ghostwriter, right? Like, it's staying true to the client. It's not using language that the client would never use. There should not be words in the affidavit that the client doesn't know what they mean, but you're polishing it up, right? You're not just transcribing exactly what they're saying verbatim, because again, as we talked, memories go out of order. When we talk, we don't always organize our thoughts in the clearest way, right? So you're definitely reordering, polishing things up, making them really clear. So to have some examples here, something that's not in the client voice would be something that's using like legal language, or maybe using like words that the client wouldn't be familiar with. I will say, right, our clients come from all different kinds of backgrounds, right? We have clients who are here in graduate school getting their PhDs who want to read their affidavits themselves and make edits to it. We have clients who are illiterate and can like sit down with you and very clearly convey their story, but may not be able to or want to or find it helpful, right, to look at their affidavit on the paper. We also don't want too much legalese, right? Take off your lawyer hat. Well, keep it on enough to, match the facts to the legal case, but don't have your legal writing hat on while you're working on the affidavit. And then finally, think about how much detail you're including, right? We try to avoid things that are really specific dates, unless there's you're really certain that client is going to remember in their interview or when they're testifying in court. Specific numbers, specific dates, those are all like kind of credibility traps, because there are things that are difficult to come up with later on. So I prefer to use like seasons, right? Like in the winter of this year, or when I was about 15, right? Things that kind of keep it vague, allow for some wiggle room, and allow for changes in memory throughout the lifespan of the case. All right, so we talked about the affidavit as being the most important part of your case. Let's talk about corroboration. So as you can see, there's some language here explaining that corroboration is required unless the applicant does not have the evidence and cannot reasonably obtain the evidence. Well, it's pretty common for asylum seekers to not be able to obtain evidence because the evidence is often in a different country, right, where that person is being persecuted, and so it can be very hard to safely access it. But wherever possible, we want to get creative about coming up with evidence and submitting it to the asylum office or to the court, because even though we know, right, that in the statute we can see here that a declaration alone or a declaration and testimony can be enough for an asylum grant, we don't ever want to leave it just at that unless, you know, there's some reason why we absolutely can't come up with anything else. So we're really looking at corroboration for each asylum element, or for reasons how we can explain to adjudicator why we don't have that corroboration. I would like to note that as we talk about corroboration, that immigration judges and asylum officers can look very carefully at authenticity of documents. So make sure that you're talking to your client and you're asking, you know, for things like hospital records from country of origin, police records from country of origin, you know, where did you get this? How did you get it? Could you get it again if you needed to? Making sure you're really tracing the origin of that document as well as the chain of custody, so that if your client is pressed on that when they are testifying, you can know that they'll be prepared to answer fully. So the affidavit matters, the corroboration matters, everything matters here, right? So here are kind of some examples of things that we might include to support a case. For country conditions, State Department human rights reports we always include, other reports from reputable international organizations like Amnesty and Human Rights Watch, UNHCR documents, domestic and foreign news sources. We encourage folks to look at domestic news sources, which might be in a language other than English, depending on the country, but that can really have information accessible, right, that may have not been reported in English language news outlets. We on the LGBT project maintain a database of country conditions packets. We try to update them regularly, and we try to update them when we know that we have a case either in-house or with pro bonos that's getting ready to move forward. Please do keep in touch with us. We can provide those packets. We can provide an index to go with the packet as well. But then, of course, make sure that you're tailoring it right to the individual case of your client who may have additional things that need corroboration. Client-specific corroboration, think about how can we corroborate facts, dates, times, events that happened, right? That can be affidavits or letters of support from family members or friends, pictures, police reports, receipts, maps, maybe going on Google Maps or even having a hand-drawn illustration can be helpful. For past persecution, we can get forensic medical exams. Please reach out to us if you think that this is something that might apply to your client, either a forensic medical exam or a mental health evaluation. Those are things that we connect clients with quite regularly. If your client had any sort of physical harm, that is likely to show up on forensic medical evaluations. I've talked to some evaluators and they've said, you know, things that people don't realize leave scars or marks, you know, an individual might not be aware, but it's something that's visible to a forensics evaluator, and that can help be an important source of corroboration. Other medical reports, if your client ever had to seek medical care due to persecution, again, pictures of harm or injuries if they have them. And then for future persecution, we can look heavily, right, at country conditions reports, affidavits or letters from similarly situated individuals. Oftentimes we have clients who are maybe in touch with someone who is still in country of origin but very closeted, or a friend who sought asylum in another country who can corroborate parts of our clients' stories. the country conditions packets themselves, I think I've said, and then expert affidavits. This isn't something that we submit in every case. We kind of have tiers of country conditions, right? There are some countries like Iran comes to mind where same-sex relationships are heavily criminalized. It is like very clearly enforced, and there really shouldn't be a lot of doubt or any doubt in an adjudicator's mind that there is a substantial risk of persecution in that country. Then we have other countries, right, where maybe the laws, there are laws that criminalize same-sex sex or relationships, but they're not maybe as regularly enforced. Then we have also countries where maybe conditions are mixed. So we see this in Mexico, or we see this a lot in Eastern Europe, in countries that have kind of are making bids, right, for EU membership. And so maybe they've recognized, they have a pride celebration in June, or they've passed some kind of legislation that like says it protects the LGBTQ community, but it turns out that the lived reality, right, is completely different from that. And I've, for example, had a client who, you know, was pressed on this by Asylum officer and said, well, yeah, they do one Pride Day in June because it gets the EU off their backs, and then they do whatever they want the rest of the year, which is all really horrible stuff. And so whether or not your client is in a place to kind of articulate those discrepancies in the law or what a government is putting out there and the lived reality, in those cases in particular, having an expert to help fill in those gaps for the adjudicator can be really helpful. And those are folks you can find online, or we can also help you get connected. When it comes to drafting the legal argument, right, that's the other piece that we need to talk about today. Keep it focused. I know that Lee did a great job in part one of breaking down those elements of asylum. And I know there was a slide that said in huge font, like, these elements are separate. Keep them separated, please, in your legal memo or your brief. We do provide samples, and we provide samples that, you know, are organized and clear, and we encourage you to, you know, work off of those. There's no need to reinvent the wheel, but of course, tailor them to your client's specific case. So if that means using a slightly different format, then use a slightly different format. If it means adapting like the structure that we've created and filling it in with the details and specifics of your client's case, you know, then absolutely do that. And if you have a question, reach out to your NIJC point of contact. We talked a little bit about case law in part one as well. Focus on BIA decisions, and so if you're in Chicago, focus on 7th Circuit case law. As we mentioned before, when we don't like our case law or we have a gap, we do, you know, pull in persuasive case law from other circuits as needed. And then, very importantly, please send all of your materials, including your legal memo or brief, to your NIJC point of contact for review prior to filing. So we ask for at least 5 days in advance, but I would say the more communication you can have with your point of contact, the better, right? Of like, hey, we're planning to file the last week in July. Are you going to be around then, right? So that everyone can get it on their calendar. Folks can check in if you seem off schedule or you run into a hiccup. And that way, right, our goal is to be here to support you and to help make sure that you feel really good about the materials that you're filing, that they're ready to go. And so the more advance notice, right, we have, the better we will be able to support you in getting these cases filed. And then finally, we want to make sure we're preserving all arguments and claims to relief. If we don't have the outcome that we wanted in immigration court, the arguments we have and are stuck with are the ones that we filed in immigration court. So again, that's where that review comes in handy. Or if you're not sure about something, do reach out to your NIJC point of contact so that we can be certain that we're getting all the arguments out there that should be out there during that initial filing. And then finally, the details, like you've put all this great work in, you have this affidavit, you have all this corroboration, these country conditions, this legal memo, but you need to actually put it together and get it to court or to the asylum office. So if you are filing in court, there's an immigration court practice manual. The index should be annotated, and so that the most important country conditions information is easy to see and read in the index. There should be alphabetical tabs on the right-hand side of the filing. Again, I'm going to go back to like that mention that I made about immigration court, that some cases right now are electronic and some are paper filing. So check carefully how you are filing and file, in the appropriate manner. And then of course, if you're in court, include a certificate of service and serve a copy on the government as well. If you're in front of the asylum office, we similarly ask that you organize and tab the original copy, and then you also need to just submit an extra copy that does not have to be tabbed. So again, this information is in our asylum manual, and it's also information that you can always reach out to NIJC staff about. I believe that it is time for me to hand this over to Hans to talk about specifics of representing LGBT individuals.
Thank you so much, Olivia. So as Olivia introduced, I'm going to jump into representing our clients. So during part 1 of this training, we covered a lot of LGBT related vocabulary. So this time I'll speak less about vocab and more about best practices when it comes to working with our LGBTQ clients. So here's a quick reminder of this gender unicorn graphic that we talked about last time. Just a refresher of all these different components that make up an individual's gender identity and or sexual orientation. So important to keep in mind that when working with LGBT clients, there's a huge diversity of identities. It's important to be flexible and open to changes people may have regarding their sexual orientation and or gender identity, including in the course of working with them. So some clients might come to understand that they're transgender, or might have a change in their sexual orientation in the course of working with them. So important to leave space open to do that. And also important to remember that some clients understand their sexual orientation or gender identity more fluidly and others more rigidly. So important to understand also that some clients feel that they were born gay and others might not come to understand it or understand that they're LGBT until they're adults. So just many different reasons to remain flexible and keep an open mind and provide space for clients' understanding of their identities to change over time. So how do you actually go about doing that? So our first tip here, take cues from your client. If there's one thing you remember from this section, it's to follow the lead of your client. So mirror their language, whether that be around their name, their pronouns, or the type of language they use to describe their identity. So you'll see in this table here, for example, if a client describes themselves as being gay, don't respond to them by saying, how long have you been homosexual? Use the language that they use for themselves. And when in doubt, ask your client. It's okay to ask them directly how they identify. So for example, if your client's transgender, ask what name they use at the beginning of working with them, and then use it. A note on clients who have a different name than their legal name. So some transgender clients have not been able or have not chosen to change their name legally for whatever reason. And so that is totally fine, and you should still use whatever name they tell you to call them. But it means that on legal documents, we would still have to list their legal name. So sometimes I like to give a heads up to clients, letting them know that we'll still need to list your legal name on some of these legal documents. But when we're communicating, I'm still going to use the name that you prefer or that you've told me. And then similarly, if you're unsure of your client's pronouns, you can ask. Another really important thing to ask, and a reason why it's really important to ask these questions, is that clients might not use the same name or pronouns or be open about their identities in all spaces. So really important to ask them, you know, what words they're using in different spaces. So for example, like you don't want to out a client using their preferred name in a piece of mail or a voicemail if, for example, they're living with family or other folks who aren't aware of their identity or who they may be afraid of coming out to. So for all these reasons, really important to take your client's lead and ask whenever you're in doubt. So we can move ahead to the next slide. So our second tip here, familiarize yourself with appropriate terminology. You know, we've really hammered this in with the first part of this training. And if you don't remember all of the vocab that we went over in the first part of the training, that's okay. There's a lot of terminology, and it's often also changing. So important just to make sure you're as familiar as possible with any vocabulary that might be relevant to your client, and then also to make sure that you're open to adapting as language changes, because it does change. And so if you see at the bottom of this slide, USCIS does have a training manual for LGBT asylum cases, as well as the Transformative Justice Law Project and the Safe Zone Project, both really helpful resources. And I'll give an example of a client that I was working with, who I was working on his work permit application. We came to the question about what his gender is, and I asked that, and he didn't understand what I was getting at, and so I tried to explain in a couple of different ways, you know, what I was trying to ask, and he just wasn't familiar with the concept of gender being anything other than what he was assigned at birth. And so after talking about that, it led to him asking questions about a host of other terms and vocabulary that he had heard before but wasn't familiar or didn't know what it meant. So for example, he asked, what does bisexual mean? What do all these other words mean? And so I say that to say that if you familiarize yourself with this vocabulary and also create a space where clients feel comfortable knowing that you are open to using these terms and also to adapting yourself, it can be a really special opportunity for clients to ask questions about terminology that they might not have felt able to ask before. So we can now move on to the next slide, please. So our tip 3, account for cultural differences. It's important to remember that our own perceptions of what an LGBT person is or is not might not be the same in every country. And so it's important to get as familiar as possible with language and kind of identity differences in your client's home country or home culture. It's also important to remember that clients might be reserved or private about their sexual orientation or gender identity, especially since most of our clients weren't able to be safely open about their sexual orientation or gender identity in their home country, or it wasn't culturally acceptable to speak about it. So be aware of that going in and know that it might take time to build rapport for those reasons. So you also want to accommodate for client language preferences. So sometimes a client might use words in their language, whether it be in English or a different language, that either are considered derogatory in English or translate directly to a derogatory term. So you'll see up here on this slide some examples of words that we've seen our clients use. The word travesti, which is a Spanish term that translates most directly to transvestite in English, which is considered derogatory in English. So important to accommodate for, and be aware of the fact that clients might use that language. That doesn't mean that you should use it in your brief. You should still use terms that are used in the US. But something that might make sense is, as Olivia was talking about, in terms of writing and working with a client on their affidavit, because you want to maintain a client's voice as much as possible, it might make sense to maintain a term that a client uses for themselves in their affidavit, both for the sake of maintaining their authentic voice, as well as acting as further evidence of the homophobic or transphobic environment that a client that a client was living in their home country. So another example you'll see here that clients often, and especially Spanish-speaking clients, we've seen a lot use is saying sexual preference to talk about their sexual orientation. So again, not something that you would want to use in your brief, but something that a client might use. And I also, while we're on this topic, want to talk about gender neutral language. So similarly to how in the US, there's a movement towards gender neutrality in language, for example, with the singular they and them pronouns, as well as other gender neutral pronouns. The movement towards gender neutrality is discussed everywhere, including many of the countries that our clients come from. So for example, in Spanish, the use of a ye with an E at the end, or the use of an at sign, so to encompass both the feminine a and the masculine o, or using X at the end of a word instead of the feminine a or the masculine o. These are all words and concepts that are being discussed in Spanish-speaking countries. It might be something that your client isn't aware of and has never heard of, but good to know that it is out there and it is being discussed across many people in many languages. So we can move to the next slide. Okay, so putting these tips into action. As we've really hammered home at this point, really important to familiarize yourself with appropriate and accurate terminology, both in English and in whatever language your client might be speaking. So for example, in Spanish, when I first started doing this job, my Spanish LGBT vocab was certainly not very robust. And so it was a matter of both doing some research and also listening to language that clients would use, and sometimes asking clients what a word meant. That's okay, and then noting it down for the next time. And if you normalize familiarizing yourself with the language, it will both help clients feel more comfortable speaking with you, and also provide a model for clients to normalize using this language. So you also want to recognize that you're going to have to talk about intimate and sometimes hard things. So including talking about romantic feelings or romantic histories, or about sex with your clients. And I think it's especially helpful when you're talking about sex or romance with a client to explain why you're asking the question. Keep in mind when talking about sexual or romantic history that in a client's country, dating culture is likely very different, and same-sex dating is very likely completely taboo. So again, it might take some time for a client to feel comfortable enough to talk about it. And something else that's also important to recognize is that just because a client might not have had open relationships in the past, doesn't mean that they don't identify as gay or lesbian. There could be a whole host of reasons that they didn't feel safe, or it just wasn't an option to have a relationship. Same thing for gender identity. Just because a person hasn't had the opportunity to pursue gender affirming medical care, whether that's because they haven't had access to it or they literally didn't know it was an option, it doesn't mean it's not something that they might want to do. So important to keep these things in mind throughout the duration of working with a client. Next, body parts and also sexual acts. So I mention this because this is also often sometimes a part of working with our LGBT clients, is talking about specific sexual acts or body parts. And there's often a lot of curiosity when it comes specifically to trans bodies and trans body parts. And something to keep in mind is that it's not always relevant to ask about a client's body parts. A lot of trans folks are really accustomed to people asking invasive questions about their bodies. So you always want to ask yourself first, why am I asking this question? Do I need to ask it? And sometimes the answer is yes. Sometimes it is needed in order to better advocate for your client. And sometimes, for example, expounding upon the details of a client's gender affirming surgery is helpful for the case, for their case. So if that's the situation, let your client know that, and let them know why you're asking and why the ways in which it is useful to their case. So they know you're not just asking because you're curious. And then finally, be sensitive, but direct and respectful. So it's okay to ask really direct questions. Sometimes you're gonna have to just do it respectfully. I often find myself repeating over and over to clients, I'm asking this question for this reason, or I'm asking this question because it'll help your case in this way. And I definitely often sometimes feel like a broken record, but I think better that than to make a client feel unsafe or uncomfortable. Next slide, please. So finally, before we move on to how to prepare your asylum case, or your client's asylum case, we wanted to make a brief note on representing detained LGBT clients. So everything that we've discussed so far applies to working with detained clients, plus a few slight differences. One added complication is that often clients are in detention because they've come into law enforcement in some way, which means they often have crimes or previous removal or deportation orders that might limit their eligibility. So that doesn't necessarily mean we can't represent them. It's just an added legal complication. Communicating with detained clients can provide special and specific difficulties and challenges for a host of reasons. One of those is for logistic reasons. First of all, every detention center has its own way of setting up client calls. So it's important to research what a specific detention center's kind of protocol for setting up client calls is and following it. Another logistical difficulty with communicating with folks in detention is that there's often time limits on phone calls. And so sometimes with detained clients, more so than other types of cases, it requires many very short phone calls, and it means having to be really efficient with your time while still trying to be as trauma-informed as possible. Clients who are detained might also not always be explained or talk about their trauma in chronological order. That doesn't mean a client isn't credible. It just means they're working through processing a traumatic event. So it's good to ask what order things happened in if it's helpful to a client's case, but really important to avoid questioning the client's perceptions of their experiences or questioning their credibility, and know that it's a part of their processing process. It's also hard for clients to talk about trauma in detention if they don't feel safe talking about it. So many detention centers do have options for private phone call rooms, but often it's still hard for clients to feel safe in a detained environment to talk about their trauma. So as much as possible, definitely advocate for clients having a private phone call room. Detained LGBT clients are also especially vulnerable to sexual abuse while in detention, which again adds to difficulty in getting a full story. As of a report that came out in 2018 from the Center for American Progress, it found that LGBTQ migrants in federal detention centers are 97 times more likely to be sexually assaulted than other detainees. So that just gives you kind of an idea of the gravity of this risk and threat for detained clients. So important to be aware of that. And if clients express some kind of harm to you in detention, we can work with you on what to do about that. Another added complication is that detained clients don't always have access to friends and family to help with evidence gathering. So for any detained case, we rely heavily on help from friends and family and people outside of the detention center to help with gathering evidence. But in the case of LGBT individuals, often they don't have good relationships with family or other folks in their lives because of an unacceptance of their sexual orientation or gender identity. So there is that added difficulty in gathering evidence. And it's a matter of getting creative with figuring out who can help and what kind of corroboration you can get. And also, as Olivia highlighted, talking about affidavits, you'll just rely more heavily than ever on a client's affidavit. And then finally, detention cases move a lot quicker than cases that are not non-detained cases. So this can often be as short as 4 to 6 weeks. So a really quick turnaround. And so just to reiterate something that Olivia said in terms of working on these different pieces of putting a client's case together at the same time, that'll be especially important when it's such a quick turnaround. So I now will turn it over to Lee, who will talk about actually presenting an asylum case.
Well, thank you, Hannah, and good morning or afternoon, depending on where you're listening in from. So the last section of our training today is going to kind of fast forward to the adjudication stage. So we heard a lot about the legal and the terminology in part 1. Olivia started out with the really important steps that you'll take while preparing your case, as well as Hannah in some considerations, especially working with the LGBTQ population. We're going to bring it home with how do you present your case in front of the adjudicator? And just remember, we're talking both affirmative and defensive. So we're talking affirmative at the asylum office and defensive at court. So you can see this flow chart here that you may have seen before. On the blue side, we have our affirmative process. So again, as Olivia started with, this is for people in the procedural posture of not having their notice to appear filed with EOIR, which EOIR is immigration court. And so this is when you have someone in this posture, then you're filing the I-589 affirmatively and going in front of the asylum office. There, when you present your case to the asylum office, your options are to be granted, yay, or referred. For if there's any reason why the asylum office can't grant asylum and the client is out of status, then they will refer that case to the immigration court, which is the red side, the defensive proceeding. So another way that people can get into defensive proceedings are to be apprehended at a port of entry. So while trying to cross a border or at an airport, or apprehended internally. So I usually see that after some sort of involvement with the criminal system or after an arrest. Again, either after the referral or in some of those other circumstances, if an NTA, the notice to appear, is issued and correctly filed with the immigration court, that's when people are officially in defensive proceedings. And so there are two types of hearings, the master calendar and the merits. So a master calendar, you can really think of it in many cases like a status hearing. So I actually have a master calendar hearing right after this training. I'm anticipating that I will plead to the NTA, which means that I will disclose to the court whether, yes, we agree with what is listed in the notice to appear, or we contest it. I know Clinic, many other places have wonderful trainings about contesting or conceding to notices to appear. Amongst immigration practitioners, you will hear a variety of experiences both ways. Another thing that happens in master calendar hearings frequently is scheduling those merits hearings. In a bit, we'll talk about that scheduling, so hold your horses there. So eventually when you do get to the merits hearing, that is the timeline in which you will file your evidence and present your case. So testimony of your client, testimony of any witnesses or experts, and making those legal arguments. So starting with the asylum office. So again, that affirmative proceeding. One of the more stressful parts of that, especially right now, is that the timing is incredibly variable. What I mean by that is that at this point in time, there is not a clear scheduling bulletin nor transparency on how those cases are being scheduled. So, for example, there are cases that we have with pro bono attorneys and internally that have been pending since 2015. We also have cases that have been filed a couple of months ago, and those cases are both being called for interviews. Spoiler, this changed under the Trump administration with the last in, first out policy, but in our experience, the scheduling has not regulated since then, which is to say that to make sure that, as Olivia said, that your G28 is on file. And another tip is to use that receipt number that's on the receipt notice. And there's a tool on USCIS online that you can track your case. If you enter that your receipt number there, then at least at this point, it will not tell you when the interview is, but it can tell you your interview has been scheduled. In my experience, that does give you a little bit of a heads up to know if your interview has been scheduled or not, because you will only get about 2 weeks notice, sometimes up to 3 weeks, but really we're talking about a short turnaround, which is why, like Olivia mentioned, it is so crucial to have already started your affidavit and your corroboration and gathering all of that evidence together. Because, so let's say 2 weeks, we know about the interview. A week beforehand, that's when we want to file all of our supporting documents with the asylum office. And like Olivia mentioned, you file the original, you file the copy, but there's no adversarial party to serve on. So then we come to interview day, and then the interview happens, and then the timeline for your decision is also relatively variable. The general timeline we see is about 10 days to 2 weeks, or on the early side, but really up to 6 months, in some cases even longer. And if you are waiting for a while after a decision, of course, throughout this process, be in contact with us. Okay, so over to the defensive side of things. Great. So with the case timing in immigration court, I wish I could say it was so much easier or better. Not necessarily true, just different. And what this graph is showing us are pending cases. So the backlog, the immigration court backlog. You may have heard of prosecutorial discretion, which is currently in flux, but had been a tool for a while for some cases to be dismissed to try to address this backlog. Again, complicated, bit out of the scope for today, but as you can see, there are many cases that are currently pending all over the country, including in the Chicago Immigration Court. Which is to say that, you know, this afternoon, when I have my master calendar hearing and I'm going to be scheduling that merits hearing, it could be in 2 years from now. So that timing does affect the ability to, you know, our pacing as we're moving to prepare our clients. So during that time period, during your waiting period, maintain contact. And I cannot have bolded or increased the size of that font enough. If you remember from the end of my little chat in part 1, life happens with your client. So maintaining contact will really help you stay ahead of any changes to your client's case, whether that might be new eligibility or complications to the existing case. It's important, of course, to develop rapport, of course, to continue to work on that evidence. So again, gather it early, gather it often. Think about the corroboration, brainstorm with your client, especially corroboration that's going to be coming from abroad. Start gathering it as soon as you are able to. While you are waiting, your client is also waiting, and the process of, especially in removal proceedings, truly, of waiting for your merits hearing causes its own kind of stress. So I find it really helpful to connect clients with mental health resources and with medical doctors as well. We do have some resources on that. I find mental health practitioners are amazing partners in working with clients on preparing and presenting cases. Biometrics. I have recently ran into some snafus with this, so I can personally plead with you to take that, don't let that slip. The process for requesting biometrics is outlined in the asylum guides that we provide that are on our website. You can be in contact with us when you run into problems, not if, but when, because those are requested with USCIS, and there's a straightforward, somewhat procedure to follow there. And then work authorization. Olivia mentioned it before, and I will talk about it a little bit more in detail, but keep track of that timing of both when a client is initially eligible to file for work authorization based on their pending asylum application and for those renewals. Because work authorization is, you know, in our bright yellow box, it's really a life changer. For someone to be able to get work authorization, get a social security number, many times allows them to enter into the formal labor market. And especially with the LGBTQ population, this population is underemployed and faces a lot of employment discrimination. So being able to have that EAD or employment authorization document is a huge benefit. So a quick note on eligibility. It depends on the asylum clock, and that is this fictional clock that tracks the days between filing the I-589, which is the asylum application, and eligibility for that EAD. There have been many shifts in this policy. Right now, someone's eligible to apply for their EAD 150 days after filing and are eligible to receive it after 180 days after filing. So that 150-day timeline is the one I track, because that's when you can submit the I-765, which is the form for the EAD application. One note on the clock is that it can stop it when there is an applicant-caused delay. Again, check our website or send us questions that you have about what is an applicant-caused delay, but just be aware of those. So if you're renewing an EAD, make sure to renew that 180 days before it's set to expire, because we are seeing backlogs in USCIS as well and long adjudication times for those EAD renewals. So again, calendar those, as Olivia gave the wonderful advice, calendar those dates. Stay in contact with your client to be able to efficiently fill out those renewal forms. And again, keep up to date with any of those changes. We have a wonderful legal team and comms team who very diligently post updates. All right, so we're going to go back to the asylum office. I should print out this slide because when I'm working with clients, I usually draw a little picture. For any Trekkies out there, I'm a lawyer, not an artist. So you can see the little diagram of what the asylum office looks like. So the box that says AO is meant to be where the asylum officer sits. There's a desk between. With current COVID practice, there is plexiglass kind of on that desk. You as the client is the interpreter. Right now, for more common languages, USCIS provides a contract interpreter over the phone. So do check on the interview notice. They will clarify which languages are being provided or not. Me is you as the attorney or the legal advocate. Just to kind of set the framework, especially given that asylum office interviews are non-adversarial. So your role is sometimes delegated to just taking notes, making sure things are on track, and to intervening if necessary. So while it says you provide the interpreter, that has been a bit in flux with current COVID guidelines. So that's just one thing to keep in mind when you are hopefully taking a case very soon with us. Has historically been true, but may be shifting. So the type of preparation that you do, I usually have 4 or 5 sometimes prep sessions with a client. During the AO interview, the asylum officer is the person asking the questions. So your role is to definitely take notes, because if there is a referral, your notes are going to be the most easily accessible record of what happened during that interview. So I do recommend taking notes. If you fill out this special form there and promise not to record anything, you can take notes on your computer there. But the questions that the asylum officer has really goes through the client's eligibility for asylum, as well as clearing through any inadmissibility issues. So, you know your client's story very well at this point. So you can kind of anticipate where might some of the sticky points be. In doing so, on that third checkpoint, talk with your client about their case. You go through those 5 elements of asylum that we talked about in part 1, and prep them, using open-ended questions for things you'd anticipate. With Nexus, how do you think the asylum officer will ask about the connection between a protected ground and the harm, for example? And another important part about preparing clients is explaining those results, explaining what referral might be, and managing expectations by giving them that information. Part of our role as attorneys and as legal representatives helping people with asylum claims is to empower our clients both with as much information about their own case, as well as their own role during their interview. I always tell my clients, this is your interview. So if you don't understand the interpreter, or if the asylum officer asks a confusing question, to say yes, to be able to say, like, I don't understand. Can you please repeat that? Or to say that they don't know. I don't know is an okay answer. I would rather have clients say that they don't know than to guess or to go beyond the scope of a question. So that is a bit on the AO process. The merits hearing process is a little bit different. I'm not going to go totally into preparing a merits hearing, but we do have plenty of resources on that. Where I'm next going is what happens next. So, at the end of the AO hearing, like we talked a couple slides back, what happens next can be a grant or a referral. In immigration court, in the defensive proceeding, the what happens next can have many more, we have a little bit more of a complicated flow chart here. So, like we spoke about in part 1 of this training, protection-based relief, when we kind of shorthand for asylum, we are often also talking about withholding of removal and relief under the Convention Against Torture. So starting with asylum, if we are granted, DHS or the government attorney can reserve appeal or they can waive appeal. So this timing is especially important when you're working with clients who are detained, because if DHS reserves appeal, which means it doesn't necessarily mean they are appealing, but they're reserving their right to appeal, they have 30 days in which to file a notice of appeal. During those 30 days, DHS takes the position that your client does remain detained. So that's a really important distinction to tack down, whether if your client's granted asylum, if DHS reserves appeal, then that just helping with that expectation that the client may be detained longer. Of course, if your client's not detained, DHS still has 30 days to actually file their notice of appeal. If the immigration judge denies relief, you have the ability to appeal as well. So in the detained context, it can be a little different. Talk with your client, explain their options, talk with us to get help evaluating those options. Otherwise, we usually almost always would want to reserve appeal, to reserve your client's right to appeal that decision to the Board of Immigration Appeals. So then a little bit differently under withholding or CAT. Again, you can appeal a negative decision. DHS can appeal a positive decision. This chart, I'm not going to go super into it. A little bit of the logistics of withholding of removal are a little bit complicated, are not as logistically relevant usually. So another quick point on detained clients is that oftentimes it's on us to help a client with their release plan. There's wonderful organizations in the Chicagoland area, including ICDI, or the Interfaith Committee for Detained Individuals, oftentimes can help with establishing a release plan, getting someone to their loved one, so transportation. But just keep in mind that is something that you should be prepared for, especially with detained clients. So another perspective on what happens after a decision. So affirmatively, AO, if we're granted, let us know right away. We want to congratulate you, of course, but there's also a timeline that asylees or new asylees are eligible for benefits. Many of the relief type orgs will have this 30-day time period of a deadline to register in benefits. So, we can help connect them with those organizations. We will provide you with some of that information as well. what comes after is there's steps of getting an unrestricted Social Security card. There's these other types of work, these other steps that happen right after a grant. Then they might be eligible to petition for family members. We have a post-asylum and refugee benefits clinic at NIJC that we can help sign people up for. So again, if asylum is not granted for any reason at the asylum office, then that's when we get referred to the immigration court. In that case, obviously, please do also contact us immediately so that we can start talking about next steps. Somewhat similarly, pardon me, after your merits hearing, then you let us know when we win. Similar deadline for benefits. A difference between the affirmative and defensive here is that on the defensive side of things, clients are not automatically granted this form called an I-94, and that's the most common proof of asylee status. So there's extra steps that you and your client will have to take in order to have an I-94 issued. But similarly, there's the other types of ways to get work authorization, unrestricted Social Security cards, and potential for benefits for family members for asylum only, not withholding or CAT. But then if there is a denial, then of course, with your client's consent, reserving the right to appeal, letting us know, and then making a plan to appeal to the BIA. Okay, I know that was a lot of information. Thank you so much. We do definitely have some time for questions. Before we jump into it, please do hold your phone up to this QR code or copy down this link to evaluation. We very much appreciate any and all feedback. It helps us to tailor these trainings to what is of interest and what's useful for you. And also, like Olivia mentioned, please be in contact with us when you have other questions. Her email address is up on the screen. But we are very happy to field your questions and to field your interest in taking pro bono cases. So as we're working through or looking through some questions, I'm going to flip through some cases that we're highlighting this month. If you were with us for part one, these are the same cases that we do have currently available for pro bono placement. It looks like all of the questions that came through the chat have been answered. But if you have other questions, put them in the chat, put them in the question box, and we'll be happy to get to them. I'm going to go through to the next case that we have for placement. We do have a couple of more minutes for questions. These three cases are cases that are on our LGBT team and specifically have LGBTQ related claims. But we also have many asylum cases that have other bases. We're calling these cases now that are on the screen gender based, because there is an element of a gender claim to them. Okay, oh, I think I see the little question button light up. Mario asks, says that they are on the West Coast. Are cases available in the Seattle area? If not, how may I help support cases elsewhere? Great question. I actually am not sure if we currently have West Coast-based cases. Olivia may know better, but we are always looking for engagement from all around the place. Olivia, I don't know if you want to step in.
Sure, I don't know specifically, but certainly sign up for our alerts, check our case list regularly. We do occasionally have cases, right? Our primary service area is Illinois, Indiana, and Wisconsin, but we do sometimes have cases. There's going to be one scrolling through here at some point that is outside our service area, and I'm not remembering off the top of my head if that's West Coast or not. I know that we do currently have one case on the West Coast. It has already been placed, but that tells me, right, that there is potential for others in the future. So there's lots of information on our website about connecting, being on our listservs, right, checking our case list to see if something comes up. And I'm also making a mental note right now that we have some West Coast outreach in case a need arises.
Okay, that brings us to time. Thank you all so much for attending and participating in both parts of these trainings. As a reminder that to let us know about your ARDC numbers for CLE credit, to take this survey, and the recording is going to be up live, well, up on the website for you to refer back to or to send to your colleagues who are also going to be, of course, taking our cases and helping our client base seek relative safety. So again, thank you for your participation, and we will see you next time.